J.D. Vance just detonated a bomb that the mainstream media is desperately trying to bury. A secret Epstein database, one that the American public was never supposed to see, has surfaced. And sitting right in the middle of it, named not once, not twice, but 114 times, is a federal judge who's been quietly ruling on cases that shape this nation. His name is Judge Caldwell. And this isn't some conspiracy theory. This isn't speculation. This is documented evidence that the Vice President of the United States just put on the record. When the second most powerful person in the country openly exposes a sitting federal judge's connections to Jeffrey Epstein's inner circle, you know something seismic has just shifted in Washington. The establishment is panicking, and they should be. Hit that subscribe button right now because this story is moving fast, and you're going to want every single update as this unfolds. The mainstream media won't touch this, but I will. Subscribe so you never miss a video. So what triggered this unprecedented revelation from Vice President Vance? For months, investigators and independent journalists have been piecing together fragments of Epstein's network. Flight logs, visitor records, financial transactions, phone records. But a comprehensive database containing communications, scheduling records, and internal notes? That was the Holy Grail. And now, according to Vance's explosive disclosure, that database exists. And it's been accessed. This isn't just another political scandal or beltway drama. This cuts to the very core of judicial integrity in America. When a federal judge, someone empowered with lifetime tenure to interpret the Constitution and decide the fate of American citizens, appears over 100 times in a convicted sex trafficker's private records, every ruling that judge has ever made comes under immediate suspicion. And Judge Caldwell has made plenty of rulings. Cases involving civil liberties, cases involving powerful defendants, cases that set precedents impacting millions of Americans. When the Vice President of the United States calls out judicial corruption tied to the most notorious trafficking network in modern history, it signals that the gloves are off. This administration isn't just talking about draining the swamp anymore. They're actively pumping it out and exposing what's been lurking at the bottom. Here's exactly what the database reveals and why Judge Caldwell should be very, very concerned about what comes next. To understand the magnitude of this moment, we need to understand what this database actually is and how it came to light. Jeffrey Epstein didn't operate alone. He ran a sophisticated operation that required meticulous record-keeping, scheduling, logistics, communications, financial transactions, and yes, tracking who visited, when, why, and how often. Intelligence experts who've analyzed similar operations describe it as running a blackmail network with corporate-level organization. For years after Epstein's suspicious death in August 2019, questions swirled about the so-called client list. But what Vance is describing goes far beyond a simple list of names. This is a relational database, structured records showing patterns of contact, communication threads, scheduling coordination, and references across multiple document types. According to sources familiar with the disclosure, the database was compiled from multiple sources: Epstein's personal computers seized during the 2019 raid, backup servers, cloud storage accounts, and physical records recovered from his properties in New York, New Mexico, and the Virgin Islands. The existence of such a comprehensive database was long rumored, but never confirmed until now. Judge Caldwell's name appearing 114 times isn't a casual mention. According to the information Vance made public, the entries span multiple years and multiple categories: communication logs, scheduling entries, event references, and what sources describe as coordination notes. Judge Caldwell was appointed to the federal bench in the early 2000s and has served with lifetime tenure ever since. During that time, he's presided over thousands of cases, including several high-profile matters involving financial crimes, civil rights, and notably, cases connected to powerful defendants with establishment ties. What's particularly alarming is the time frame. According to preliminary analysis of the database entries, Judge Caldwell's appearances in Epstein's records span the period when Epstein's operation was most active and when he was receiving inexplicable legal protections that allowed him to avoid serious prosecution despite overwhelming evidence. The question that's now tearing through Washington: was Judge Caldwell part of the protection network? Did his rulings, directly or indirectly, benefit Epstein's associates? And if so, what cases need to be immediately reviewed? The vice president wasn't subtle about the implications. During the disclosure, Vance reportedly stated that the American people deserve to know who was compromised, and they will know. That statement alone sent shockwaves through the federal judiciary. Smash that like button if this is making sense so far. And drop a comment. Had you heard about this database before today? I read every single comment. Here's what the database entries actually show, and why legal experts are calling this a 5-alarm fire for Judge Caldwell. First category: direct communication logs. According to Vance's disclosure, Judge Caldwell appears in communication records that suggest ongoing contact with Epstein's scheduling coordinators. These aren't accidental mentions. They show repeated outreach over a multi-year period, dates, times, reference codes that investigators believe correspond to specific events or meetings. One entry, reportedly dated from 2008, references Judge Caldwell in connection with what's described as legal coordination, a phrase that, given Epstein's legal troubles that same year, takes on an extremely dark meaning. 2008 was the year Epstein received his infamous sweetheart deal in Florida, a non-prosecution agreement that legal experts have called one of the most corrupt arrangements in prosecutorial history. Was Judge Caldwell providing guidance? Was he part of the network ensuring Epstein's protection? The database entries raise exactly these questions. Second category: scheduling records. Judge Caldwell appears in what sources describe as event planning documents, references to gatherings at locations associated with Epstein, including his New York townhouse and Caribbean properties. These entries don't necessarily prove attendance, but they prove he was being tracked, invited, or considered for events that were not open to the public. Third category: financial reference codes. This is where it gets particularly damning. According to analysts who've reviewed the database structure, certain entries contain alphanumeric codes that investigators believe correspond to financial transactions. Judge Caldwell's name appears adjacent to several such codes. The precise meaning of these codes is still being analyzed, but the implications are obvious. If a federal judge was receiving anything of value from Jeffrey Epstein's network, it constitutes not just ethics violations, but potential criminal conduct. Fourth category: what sources call leverage files. Epstein was widely understood to operate a blackmail scheme, collecting compromising information on powerful individuals to ensure their cooperation or silence. The database reportedly contains a section of tagged references that investigators interpret as leverage indicators. Judge Caldwell's entries include several such tags. Former federal prosecutor Mark Weinstein, who reviewed the disclosure, stated, "If these entries are authentic, this isn't a judicial ethics issue. This is criminal corruption at the highest level of the federal judiciary. We're talking about potential bribery, obstruction of justice, and conspiracy charges that carry decades of prison time." Here's the kicker: Judge Caldwell is still serving on the federal bench. As of this moment, he still has the power to decide cases. He's still ruling on matters affecting American citizens. And he's apparently never been investigated for his Epstein connections, despite the database existing for years. That last point is what has investigators furious. This database was in government hands. The FBI had it. The DOJ had it. And for years, nothing happened. No investigation, no disclosure, no accountability, until J.D. Vance decided enough was enough. The vice president's decision to go public represents a fundamental shift in how this administration is approaching the Epstein files. Previous administrations sat on this information. This one is weaponizing transparency against the protected class. And Judge Caldwell's 114 entries are just the beginning. The bombshell moment came when Vance disclosed a specific entry that sources describe as the smoking gun. According to the vice president's statement, one database entry from 2010, 2 years after Epstein's sweetheart deal, contains a scheduling note that reads, "Caldwell confirmed for weekend. Legal discussion with GM, Ghislaine Maxwell." The room went silent. Reporters who'd been taking notes stopped writing. Camera operators adjusted their shots to capture the gravity of the moment. A sitting federal judge confirmed for a weekend meeting with a reference to legal discussions with Ghislaine Maxwell, the woman now serving 20 years in federal prison for sex trafficking and conspiracy. That single entry transforms this from a suspicious pattern into what legal analysts are calling direct evidence of conspiracy. This isn't 6 degrees of separation, said one investigator who spoke on condition of anonymity. This is direct coordination. A federal judge, a convicted trafficker's partner, a scheduled meeting, legal discussions. This is the kind of evidence that ends careers and starts prosecutions. When the vice president finished reading that entry, the implications were clear. This isn't just about Judge Caldwell. This is about an entire network of protected individuals who operated with impunity because they believed their names would never come out. They believed wrong. Don't go anywhere. What comes next exposes why this has been hidden for so long. Drop a comment right now. Are you surprised a federal judge is connected to Epstein? Or did you always suspect the rot went this deep? I read every single one. This isn't the first time judicial corruption connected to powerful networks has threatened to upend the American system. But the scale and implications here are unprecedented. Think back to the 1980s. And the Franklin Credit Union scandal. Allegations of child trafficking connected to powerful political figures, including claims that implicated judges and law enforcement. That investigation was systematically shut down. Witnesses died under suspicious circumstances. Evidence disappeared. The establishment closed ranks and protected its own. Then there was the Kids for Cash scandal in Pennsylvania, where judges Mark Chivarella and Michael Conahan were convicted of accepting millions in bribes to send children to for-profit detention centers. That case proved federal judges could be corrupted, but it was treated as an isolated incident, 2 bad apples in an otherwise clean barrel. The Epstein case shatters that narrative. What we're seeing now is evidence that the corruption wasn't isolated. It was networked. Judges, prosecutors, politicians, business leaders, all connected through an operation that traded in human beings while maintaining a veneer of respectability. The key difference between those earlier scandals and today, the current administration's willingness to break ranks. Previous administrations, Republican and Democrat alike, sat on the Epstein files. Bill Clinton's connections to Epstein were documented but never fully investigated. Prominent figures from both parties appeared in flight logs, yet faced no consequences. For decades, the bipartisan establishment protected itself by protecting each other. What J.D. Vance just did, publicly naming a sitting federal judge connected to Epstein 114 times, represents a complete break from that omerta. The Vice President of the United States just told the protected class that their protection is revoked. The historical pattern was clear. When powerful people are exposed, the system circles wagons and waits for the news cycle to move on. But this administration isn't waiting. They're pressing forward. And that changes everything. Legal experts across the spectrum are calling this disclosure a seismic event, one that could trigger cascading investigations and constitutional challenges. Professor Alan Rothberg of Georgetown Law, a specialist in judicial ethics, told reporters that the standard for judicial recusal is whether a reasonable person would question the judge's impartiality. What we're seeing here obliterates that standard. Every case Judge Caldwell has touched is now potentially tainted. He emphasized that if even a fraction of the database entries prove what they appear to show, Judge Caldwell's rulings could be challenged en masse. Defense attorneys will be filing motions within days, Rothberg predicted. Any conviction where Caldwell presided, any ruling that went against a defendant, it's all now subject to review. The legal chaos this creates is almost incalculable. Meanwhile, former federal prosecutor Sandra Chen, who spent 15 years handling public corruption cases, stated that this isn't just about one judge. The database entries suggest coordination. Coordination means conspiracy. If Judge Caldwell was receiving information, guidance, or anything of value from Epstein's network in exchange for favorable treatment, we're looking at RICO-level charges. RICO, the Racketeer Influenced and Corrupt Organizations Act, was designed to dismantle organized crime networks. Chen's invocation of RICO suggests that investigators may be preparing to treat the Epstein network not as a collection of individual crimes, but as an ongoing criminal enterprise. Constitutional scholar Victor Daniels added crucial context. The implications for judicial independence are profound. Federal judges have lifetime tenure, specifically to insulate them from political pressure. But that protection was never intended to shield criminal conduct. What we're witnessing is the tension between judicial independence and accountability reaching a breaking point. Even sources typically aligned with the establishment are acknowledging the severity. A prominent legal commentator who requested anonymity admitted, "I've defended judicial independence my entire career, but if these entries are authentic, Judge Caldwell didn't just violate ethics rules. He potentially compromised the integrity of the federal judiciary itself. That can't stand." Former DOJ official Marcus Webb noted the institutional stakes. Every time a corrupt judge is exposed, it damages public trust in the entire system. But the alternative, covering it up, damages that trust even more. Vance is betting that transparency now prevents a larger crisis later. It's a high-risk strategy, but given what's in that database, it may be the only option. Do me a favor and slam that like button. It genuinely helps this video reach more people who need to see it. The algorithm rewards engagement, and every like pushes back against suppression. So what does this actually mean going forward? The implications cascade across the legal, political, and institutional landscape. First, Judge Caldwell faces immediate calls for resignation or impeachment. Federal judges can only be removed through impeachment by the House and conviction by the Senate, a process that's only succeeded 8 times in American history. But the political pressure building around this disclosure is unlike anything we've seen since the Nixon era. If even a handful of Caldwell's rulings can be directly connected to his Epstein ties, impeachment becomes not just possible, but politically inevitable. Already, congressional sources indicate that the House Judiciary Committee is preparing subpoenas for the complete database records. The chairman reportedly stated that no judge is above the law, and these allegations demand immediate investigation. Second, every case Judge Caldwell has adjudicated is now under a cloud. Defense attorneys are already preparing habeas corpus petitions, arguing that their clients were denied impartial justice. Prosecutors who secured convictions in Caldwell's courtroom are facing questions about whether those convictions can stand. Civil litigants who lost cases are consulting attorneys about reopening their matters. The administrative burden alone is staggering. Thousands of cases spanning decades, each requiring review for potential taint. Court systems already stretched thin will face impossible demands. Justice delayed is justice denied, and the delays this creates could last years. Third, the broader Epstein network faces renewed scrutiny. If Judge Caldwell is connected through 114 database entries, how many others appear with similar frequency? Vance's disclosure specifically mentioned that additional names would be forthcoming. Washington insiders are reportedly panicking, unsure who will be named next. The strategic implications are significant. By releasing names incrementally, the administration keeps this story in the headlines while maximizing pressure on compromised individuals to cooperate. This is precisely the approach prosecutors use to crack organized crime networks. Start with the periphery, create pressure, flip witnesses, move toward the center. Fourth, the political landscape is permanently altered. Democrats who might otherwise oppose the administration's judicial agenda now face an impossible choice: defend a judge connected to Epstein, or acknowledge that the administration is exposing genuine corruption. Neither option is politically viable. Meanwhile, Republican unity on judicial matters solidifies. Any GOP member who wavers on holding compromised judges accountable will face primary challengers armed with devastating attack ads. Congressman X protected Epstein's judge writes itself. Fifth, and perhaps most importantly, this sets a precedent for transparency that cannot be easily reversed. Previous administrations maintained the Epstein files as classified or sealed. This administration is treating disclosure as a weapon against the establishment. Once that precedent is set, future administrations will face enormous pressure to maintain it. The implications for democracy itself are profound. If the American people can see who was connected to Epstein, judges, politicians, business leaders. They can make informed decisions about who deserves their trust. That transparency, however painful, is the foundation of self-governance. And then Judge Caldwell made it even worse. Within hours of Vance's disclosure, Judge Caldwell's attorneys released a statement that legal analysts are calling catastrophically misguided. Instead of addressing the specific database entries, the statement attacked the disclosure itself as politically motivated character assassination and claimed that any contact with individuals later accused of crimes does not constitute evidence of wrongdoing. The statement went on to call the vice president's disclosure a dangerous assault on judicial independence and warned that weaponizing unverified databases to attack sitting judges threatens the very foundation of our constitutional order. Not a single specific denial, not one entry refuted, no explanation for the 114 mentions. Legal crisis management experts were stunned. Rule 1 of responding to a scandal: address the specific allegations, said media strategist Patricia Wells. This statement addressed nothing. It attacked the source. It invoked abstract principles, but it didn't deny the substance. In my 20 years advising clients in crisis, I've never seen a response this self-destructive. The failure to deny is itself evidence. When someone is accused of specific conduct and responds with process objections rather than substantive denials, experienced observers draw obvious conclusions. Judge Caldwell's statement also included a threat of defamation litigation against, quote, any party that repeats these baseless allegations. Legal experts immediately pointed out the irony. Discovery in a defamation case would require Caldwell to prove the statements false, meaning he would have to explain under oath what those 114 database entries actually represent. If he files that lawsuit, he'll be deposed, noted attorney Michael Torres. He'll have to answer specific questions about every entry, every meeting, every communication, every financial reference. There's no way he actually follows through. The threat is empty, and everyone knows it. The response also notably failed to call for an independent investigation to clear his name, something an innocent person would typically demand. Instead, the statement demanded that, quote, these allegations be rejected without investigation as politically motivated. When your defense is attacking the investigation rather than addressing the evidence, you've already signaled guilt. But beyond the immediate political and legal fallout, this moment represents something much larger than one compromised judge. This is about whether America has a one-tier or two-tier justice system. For decades, the American people have watched as powerful individuals escape consequences that would destroy ordinary citizens. Martha Stewart went to prison for lying to investigators about stock trades. Meanwhile, Epstein's network operated for years with virtual impunity. Ordinary Americans lose their homes over tax debts. Connected individuals receive sweetheart deals that erase their crimes. Young black men serve decades for minor drug offenses. Elite predators serve months in county jail with work release. The promise of equal justice under law, inscribed on the Supreme Court building itself, has become a cruel joke to millions of Americans who see the system protect the powerful while crushing the vulnerable. What J.D. Vance just did is demand that the promise be kept. If a federal judge can be exposed for connections to the most notorious trafficking network in modern history, if that judge can face consequences, then maybe, just maybe, the system can be redeemed. This isn't about partisan politics. This is about whether the law means anything at all. Every American, regardless of political affiliation, should want to know if the judge deciding their case is compromised. Every American should want a judiciary that serves justice, not powerful networks. Every American should want the truth. That's what's at stake. Not one judge, not one database. The legitimacy of American justice itself. Subscribe right now if you want continued coverage of this story. This is just the beginning. More names are coming, and you'll want every update as they drop. Hit subscribe and the notification bell so you never miss a video. Here's where things stand right now. Vice President Vance has indicated that additional database disclosures are forthcoming. Sources close to the administration suggest that Judge Caldwell is just the first name, and that the rollout strategy is designed to maximize pressure on the broader network. Congressional Republicans are moving rapidly. The House Judiciary Committee has scheduled an emergency hearing for next week, specifically to address judicial integrity and the Epstein files. Subpoenas for the complete database are expected within days. Legal scholars anticipate the hearing will feature testimony from federal investigators, former prosecutors, and potentially whistleblowers from within the judiciary. Meanwhile, the federal courts are bracing for impact. The Administrative Office of the U.S. Courts issued a terse statement acknowledging the, quote, serious nature of the allegations and indicating that, quote, appropriate review procedures will be followed. Legal experts interpret this as preparation for either voluntary resignation or formal judicial conduct proceedings. Judge Caldwell himself has not appeared publicly since his attorney's statement. Sources indicate he has recused himself from all pending cases, a tacit acknowledgement that his impartiality is compromised. However, recusal from future cases does nothing to address the thousands of cases he's already decided. Defense attorneys across the country are organizing. A coalition of criminal defense lawyers announced plans to file coordinated challenges to convictions obtained in Caldwell's courtroom. Our clients deserve justice, the coalition's spokesperson stated. If the judge was compromised, every conviction is suspect. The DOJ has remained officially silent, but sources indicate internal discussions about whether to open a formal criminal investigation. The complicating factor? Any investigation would need to address why the database wasn't acted upon years ago. That question implicates previous administrations and potentially current DOJ personnel who were present during the cover-up. Keep a close eye on three specific developments in the coming days. First, whether additional names are released and who they are. Second, whether Judge Caldwell resigns or fights. Third, whether congressional Democrats join the investigation or attempt to dismiss it as political. Each of those decisions will shape how this story unfolds. The stakes have never been higher. The evidence has never been more damning. A sitting federal judge stands exposed, linked 114 times to Jeffrey Epstein's secret database. And the Vice President of the United States just made sure the world knows. What happens next will determine whether America has equal justice under law or whether the protected class remains untouchable. This isn't just another news cycle. This is a reckoning, decades in the making. The names are coming. The network is being exposed. And the establishment's wall of silence is crumbling. Hit subscribe and the notification bell. Share this video with everyone who needs to understand what's happening. The truth is finally coming out, and you'll want to see every revelation as it drops. I'll see you in the next one.